electoral system, and by extension, democratic leadership, must derive its legitimacy from relevant laws that reflect the unique setting and modern practice. And so the new Electoral Act 2022, despite the challenges, has been lauded as a product of the robust contributions and years of advocacy by the civil society, and albeit for once, committed leadership. It's the challenges that interest us on the program today, as the week opened with news about the CBN governor, Godwin Emefiele, petitioning a court asking it to declare that he can contest for the presidential ticket of any political party while serving as the governor of the Central Bank of Nigeria. And while the week unfolded, Parliament hurriedly amended Section 84(8) to allow statutory delegates vote in party conventions, congresses, and meetings. What's the goal of Parliament with these hurried amendments? And is this perhaps the last of amendments as far as the Electoral Act is concerned? Welcome to Hard Copy, an evening of frank conversations reaching you from Channel's television studios here in Lagos. I am Bukola Samuel Wemimo. Thank you for joining us on Hard Copy. My guest today is the spokesman, House of Representatives. Is also the lawmaker representing Bende Federal Constituency in Abia State, Honorable Benjamin Kalu. Welcome to Hard Copy.
Thank you for having me. I'm glad to be here.
Yeah, we're glad to have you. So very quickly, what's the goal of the seemingly hurried amendment of the new Electoral Act to now allow statutory delegates participate in convention and in other meetings?
I'm sure you are referring to Section 29 of the Electoral Act.
That would be
no, you're referring to Section 84. 84(8). Yeah, you're referring to Section 84(8) of the Electoral Act. We discovered that if left, as it were, it's going to differentiate certain classes of people which were not incorporated by the provisions of that Section 84(8). It's not a new section of the Electoral Act, a new subsection. It's just an amendment to it to include those who were not attended to by the previous provision, which read in addition to those who are classified as statutory delegates in the constitution of various parties, which includes Mr. President, the governors, the members of National Assembly, and also the state houses of assembly. So
you, in your explanation, you said you didn't want to disenfranchise certain individuals from participating in conventions and other meetings, and that's the reason informing your amendment. So who are these certain individuals? And might I add that what's the difference between these certain individuals or statutory delegates and elected as captured in the electoral law before your amendment?
The truth remains that various political parties define those who fall under the bracket of automatic delegates, which you can call the statutory delegates. Statutory in the sense that they are recognized by the statutes of that particular political party. And these classes of people were not part of what was, carried by Section 84(8). It excluded them. If you read in between the lines, the fine letters of that particular provision, there will be no place for Mr. President to participate in that election, no place for the governors from various parties, irrespective of the political party, no place for members of National Assembly. And if we allow it as it is, it will not be giving us the kind of credibility that we want in our electoral space. We're not going to be lawmakers forever. And we're making a law that will outlive us. The law should not be discriminatory when we draft them. In this case, that particular 84(8) was discriminatory against those who have been acknowledged by the various constitutions of the party as automatic delegates. And if you exclude them, you make them automatic delegates in your party constitution, and then you exclude them from participating in the election in the Electoral Act. And the supremacy of Electoral Act is over that of the party's constitution, just like the constitution is bigger than that of it's more supreme than that of the Electoral Act. So in the hierarchy of laws, Electoral Act is very important when you consider it against the constitutions of the various political parties. So to that effect, the description of the various political parties' constitution and as as statutory delegates or automatic delegates will hold no water in conducting this election. If somebody goes to court that the Electoral Act did not recognize you, and so you cannot participate, if you participated, that election is ineffective, then the court will give it to the person. So in order to avoid such litigations tomorrow, we needed to bridge that gap.
Honorable Kalu, might I ask, are you recontesting to retain your seat, Bende Federal Constituency in Abia State?
Definitely. The problems of Bende.
So you are not going to be there forever, but you're going to be there if you're elected for another 4 years. In the same way,
yes,
your other colleagues may not be there forever, but many, a handful at least, if not 100%, are campaigning for re-election to retain their seats. So it is for this reason that political watchers are saying that your hurried amendment is self-serving.
No, wrong description, wrong analogy, because you don't have to be a member of the House of Representatives in the next tenure to be an automatic delegate, especially my party that I come from, that is the APC. Having served in the National Assembly, automatically you are an automatic delegate in most of the congresses and conventions. I'm sure the same thing is applicable, when you look at the constitution of PDP, because I was there before as a member of PDP, a strong member of PDP. So it runs through most of the political parties. There are people who are given automatic recognition by the roles they have played previously in enhancing democracy in whatever level that they participated, either state or federal. So it is not about those who are coming back to the National Assembly. It's about recognizing those that be recognized by the constitution of the various parties. We cannot jettison that the spirit behind the letters of the propositions and the provisions in the constitution of the various political parties. We have to sustain it because it's actually good. We, as lawmakers, sustain what is good, and we jettison what we feel is a mischief, to make sure that the space is cleared in our efforts towards electoral reform.
The law, as it is, captured in the Electoral Act currently, states that the parties must explain how they elected their delegates. Now, who determines how the elected delegates are elected?
Of course, the party constitution has express provision that must be read in line with the provisions of the Electoral Act and also in conjunction with the Constitution of the Federal Republic of Nigeria. That is how we apply our laws. If there are related laws to a particular subject matter, you don't read one in isolation of the others. So a combined reading of all the statutory provisions that governs the particular state will be sufficient in declaring who is elected or who is not elected. But let me say this. Most parties, it is internal workings of the party to, in compliance with these statutory provisions, organize their own election under the observation of the INEC. There must be a provision in your constitution that invites the unbiased umpire to witness the process and to make sure that the process is clear of any wrongdoing, and it's transparent, it is credible enough for it to pass as an electoral process. If they say no in the course of the observation, definitely that process will be flawed.
Let me quickly come in there. And in many states, in all states, the governor of that state is the leader of the party and has a say or is in control of the political structure as it's understood in politics. So in that regard, Parliament parliamentarians must protect themselves, because if the governor determines who carries or who holds the party's ticket, becomes the party's flag bearer, either for Senate and House of Representatives. And it's not always that parliamentarians are in rosy relationship with their governors. That's another analysis I want to process through you. So in that regard, many say that your hurried amendment is self-serving.
Not at all. That you are part of the delegates to vote in an election does not mean that you are vote to make the number of votes a majority vote. You know, what carries the day is the number, and you're just a single digit.
You have just a few days before the deadline given by INEC for the primaries to be conducted, and yet the Parliament has quickly, effected an amendment to the Electoral Act. How confident are you that you're going to get this amendment through before the date for your primaries, particularly because INEC is saying, look, the dates stand and it's not going to be extended?
We are actually in support of what INEC says. We're actually in support that Section 29 of the Constitution, of the Electoral Act, that provided for the 180 days should be sustained. If you are aware, if you may recall, recently, a coalition of political party leaders approached INEC to ask for the dates to be reduced from 180 days to about 150 days, which I considered a wrong call, because the INEC don't make the law that governs them. It is a piece of legislation, a product of a piece of legislation. And based on that, the right point of call ought to have been the National Assembly. But probably when they realize it, they try to bring it before the Senate. The reason behind making this 180 days, the legislative intention was to give INEC sufficient time to handle their logistics and planning, and also to cure all litigations, issues arising from primaries. And, like you have the pre-election issues that goes up to Supreme Court sometime because there was no sufficient time to resolve them before the election. And we want to reduce the amount of litigations on the corridors of the court, by making sure that sufficient time is given to political parties to take care of their internal issues before the general election.
You're saying that even though you're guaranteeing that INEC's timetable will be sacrosanct, yet you're confident that your amendment will be assented to before INEC's deadline?
I'm confident. His desire was to leave a good legacy. And this is one of the reforms that Mr. President has looked forward to. It has gone to him 6 times, but this time, due to our collaboration, cooperation, understanding, and partners in nation building, he has assented to the Electoral Act, which failed so many times. The same way I said it openly that Mr. President will assent to it, and it finally happened. The same way I said Mr. President will assent to PIB to become PIA, that I had confidence in Mr. President to do this, and it came to happen. It's the same way I'm saying, because this is good for our democracy, for the advancement of our democracy, for the electoral space. Mr. President is going to assent to this amendment.
It's just a few weeks to your primaries, Honorable Kalu. And have you factored in the need for other agencies' input to this amendment? And that's now quoting the Attorney General of the Federation, who reacted to the Abia State Court, which we're going to get to, by the way, court verdict on 8412, that the process of deletion is ongoing. So have you factored in the input of other agencies of government and the possibility that Mr. President may not assent to it? What happens to your goal of self-preservation?
I have said it before, and I'll say it again, that Mr. President will assent to it, and this one does not need the input of various agencies. Which agencies in question are you talking about? This is one of the ways of making the wishes of the political parties to count. If it doesn't count, then who are we making the law for? Which agency are we talking about in this case?
Now, what's the official position of the House of Representatives to the Abia State ruling on Section 8412 of the new Electoral Act? And, of course, the most recent reaction of the the appeal court to the same portion of the act?
The position of the National Assembly with regards to 8212 and what happened to Mahia has been reflected in the appeal that was processed by the legal team defending the National Assembly before the Federal Court of Appeal. And we just heard yesterday that a judgment has been given. And I must make this point clear that we contested the position of the judgment Mahia. There was raised issues on that. And one of the issues we raised, which is issue number one, has to do with jurisdiction, to have been canvassed by those directly affected. On the basis of these, we raised the issue one and said, there's a lack of locus. There's no locus standi, and there's no nexus between the man who went to court and the subject matter of the case. And also, we raised issues on the so-called infringement of various sections of the Constitution. But as you know, the issue of jurisdiction is a very important issue. And that was why the Court of Appeal, reading from what we got from the social media, I must make this clear to Nigerians that we are yet to get the CTC, a certified true copy of that judgment. And I'm not going to speak so firmly until we read it. It is, if the prior court did not have jurisdiction and you were favorably disposed to it, and you rule positively that they didn't have jurisdiction, what are you doing with the subject matter of 8412? So one would have expected, it is not a wrong expectation management for one to say, at that point, the issue bordering on 8412 was not even supposed to be a matter to be proceeded on. It's supposed to have died a natural death there, because to do otherwise is to try to put something on nothing and expecting it to exist. And it's an unknown practice in law. Something must lie on top of something. And if there is no jurisdiction, where is that 8412 standing? But we'll see how the CTC, the letters, the warden is couched. We'll look at it. And then we'll also see how the Supreme Court, in their wisdom, will look at this issue. Because
Kalu, you are more temperate in your reaction or articulation of the official position of the House of Representatives to the rulings to 8412. But the majority leader is more vehement in his condemnation, and he said in a report by our correspondent that no other democratic institution has a right to infringe on the legislative right of the National Assembly. So it would seem that the National Assembly sees it as an affront if we also look at the reaction of other members of the upper chamber this time that see, the ruling of the court to what he has done, that he shouldn't be allowed to stand, that if not, legislation of the National Assembly in the future will be countered. Do you see this as an affront that perhaps the National Assembly has not fully thought out its legislation before they become law?
In the doctrine of separation of power, if we are asked to make laws, the legislative intention must always, at all times, be sought for and understood and be allowed to make laws that will help in curing the mischiefs in the society. We should not interfere with the judicial function or the executive function. But same is applicable to them. The issue is that there is no jurisdiction. 8412 cannot stand. If you want to debate on the constitutionality or otherwise of 8412, there should be a commencement of another action by somebody who has locus standi, and the process will go through. But this one is dead on arrival. And that is why I said during my press briefing that the spirit of 8412 still lives on. And I'm happy. Now, Mr. President, in his wisdom, and as a Democrat, has seen that the intention of the legislature was a good one. And he has ordered all the people who have shown interest, who are working with him, to resign and face, what they want to achieve, the aspiration.
And I'm glad you talked about the spirit of 8412 somewhere along the line of your commentary, which is where I want to pick up from, specifically to take it a bit to the activities of the National Assembly itself. Granted, you would say that you are politicians and not political appointee, but when you begin your campaign, you know, the National Assembly thins out when you all go home to campaign for re-election. Should the business of legislation suffer a vacuum as well? Is that not a distraction as well? So why shouldn't what applies to the goose also apply to the gander? You know, why shouldn't the members of the National Assembly also resign and allow the political space get a breath of fresh air from others who would want to campaign for election into the Senate or House of Representatives?
It is a wrong analogy for you to think that we shut down National Assembly for campaign. We don't do that. If there is any reason for us to come back to attend to national issues, we always do that. Just like yesterday, we came back. We had adjourned to 24th. And why we did the adjournment was to enable members of National Assembly not to be defranchised in working with the various delegates at various levels to prepare them for election or standing to be elected.
Honorable Kalu, you may say that the National Assembly does not necessarily shut down, but it's not as vibrant. Yes. During the electioneering period, I'm sure you'd agree with me that during the electioneering period, the National Assembly is not as vibrant. The corridors of the National Assembly is not as vibrant as when, you know, you are settled into the business of legislation proper.
It depends on what
at that time,
it depends on what
the complex is visibly empty, maybe not empty, but you know, a good number of the National Assembly are busy with campaigns. And it's the reason that you have 3-time returnees, lawmakers returning to the National Assembly, 4-time returnees to the National Assembly. So the argument is that why shouldn't it apply to the National Assembly as well, so that the opportunity can be given to other brilliant minds, you know, to participate in the political space?
It applies to National Assembly. If the directors in National Assembly, the permanent secretaries and all the rest of them chooses to contest the election tomorrow, they have to resign. It's as simple as that. And when you talk about National Assembly, it's not about just the elected individuals that make up the National Assembly. We stand on a tripod. We have the Senate, the House of Representatives, the bureaucrats, the technocrats, you know, who handle the affairs. It is functioning. They don't shut their doors during the election. The clerk of the National Assembly is working, producing laws, making sure those that are supposed to be prepared to go to Mr. President for assent, they are being prepared, dusting motions and making sure that it is communicated to the various MDAs, you know, relevant to the proposition of the resolution of that particular motion. It doesn't shut down. National Assembly, what do you think we do? The only thing we do is to walk into plenary and go back. That is not what National Assembly does. It's a wrong perception.
Honorable Benjamin Kalu, you put forward strong arguments, difficult to contend with, but I'm sure that the debate continues from here. Thank you very much for being on Hard Copy.
Thank you for having me.
Are you as convinced as my guest is that President Muhammadu Buhari will assent to the amendments by the National Assembly on Section 84, subsection 8 of the new Electoral Act before INEC's deadline for political parties to conduct their primaries? Your answers are welcome on the handles now showing on your screen. Thank you for watching Hard Copy. I am Bukola Samuel Wemimo. Bye for now.